Welcome to the Kent Lapp Podcast.
All right, the judicial branch. Talk us through it, top to bottom.
Sure. Okay. So the only court that's mentioned and only judges that are mentioned in the Constitution is the Supreme Court, and that there are judges of the Supreme Court. The rest of the courts are all established by Congress. The Constitution says they can establish it however they want to. So the way that they've established it in the federal system, and I can talk about the state system a little bit, is there's the Supreme Court with 9 justices, and we can talk about whether packing the courts is right or wrong. The Constitution doesn't say how many justices have to sit there. They're appointed by the president, confirmed by the Senate for life. Then you have the courts of appeals, which are separated into what are called circuits. So you have the First Circuit, the Second Circuit, the Third Circuit. It goes up through the 11th Circuit, and then there is what's called a federal circuit. So, and I can talk about that. So the 1 through 11 are divided by geography. So 1 is New England. 11 was actually created out of the old 5th Circuit, and it includes 11 is Florida and Georgia and I want to say Alabama. Tennessee is in what's called the 6th Circuit. So it's this weird finger-like circuit that includes, if the map is still up, it includes Tennessee, Kentucky, Indiana, and Michigan.
And these are the courts of appeals?
This is the 6th Circuit Courts of Appeals. So,
okay, so what would he Google if we want to try to find this map? Because it probably exists,
yeah,
right?
so you could just look for Federal Court of Appeals
just
map.
Google Federal Court of Appeals map. Great.
And then
see that.
within the circuits, there are districts. So we already talked about that. Tennessee has 3 districts. So let's just say you file a lawsuit in federal court, a contract dispute that can be filed. Not everything can be filed in federal court. We can talk about that. You have to have what's called federal jurisdiction. Their federal courts are.
That's it right there.
Yeah, so that's it. So you can see Tennessee. Look at how weird 6 is.
It's very vertical.
Very vertical. And then the 11th and 5th used to be together, and then they divided it up because it's obviously, massive. Think about
it's
all
so
the people.
big.
Yes, it's way too much for one circuit. And then the 9th is huge too. Look how big the 9th is.
Yeah, wow.
And then the 9th also includes Alaska and Hawaii. The 1st includes Puerto Rico and the U.S. Virgin Islands.
Okay.
And I want to say the 9th also includes Guam. Guam, any federal territory also has a federal court. So if you want a plum job, just become the federal judge in Guam. You have a nice, tropical location.
Yeah, that
you get paid a federal salary.
at all.
I'm sure you don't have a huge caseload.
But is number 3 just Pennsylvania?
Pennsylvania
No, and Delaware.
and Delaware and New Jersey.
Oh, wow. It's so tiny.
Yep. And then the 2nd is Connecticut, New York, and I guess Vermont. And then New Hampshire, Massachusetts, Rhode Island, and Maine are in 1, along with Puerto Rico.
Now, why is, obviously Pennsylvania, Delaware, and the other state in there, that's so many less people than, what is it, the 9th out there, Andrew, the California and all that?
Yeah, that doesn't seem fair, does it?
Yeah, why is that?
Part of it is just because of the expansion westward, right? A lot of these circuits were established before the West was really settled. And so maybe when the West was settled, you could have a 9th Circuit that was that big because there weren't that many people living there.
Okay.
Over time, it's much harder to kind of keep adding more circuits.
I see.
The only other circuit that's not mentioned is what's called the Federal Circuit, and that handles all federal cases involving intellectual property. So trademarks, patents, they have their own circuit. The law is so nuanced with intellectual property. I think the thought was to have these specialized judges that deal with it. What's interesting, though, is they get overturned, the federal circuit, by the Supreme Court more than any other circuit. So maybe there's a question of whether we should have maybe generalists doing these IP cases. But in any event.
That is interesting.
And so this is actually, you can see it's divided by district too. So you see in Tennessee, Western, Middle, Eastern. And then
I see that.
if you look in Alabama, Southern is really half the state, right? It doesn't really seem Southern. So my hometown in Mobile sits in the Southern District of Alabama, but so does everything kind of, so does Tuscaloosa.
Sure.
And then the middle has Montgomery, Auburn, and then the northern has Birmingham, Anniston, Huntsville. And now, the northern has by far the most population in the state of Alabama. And the middle has almost nothing. Montgomery's not very populated. Auburn's not very. Those are the 2 biggest cities. Maybe Enterprise, Opelika. We're getting smaller and smaller.
Yep. So for those listening that can't see our TV, we're looking at a map which has 9. Is it? No, it's 11. 11 different circuits, we're calling them. But what does that mean? What goes on in these circuits?
So they hear appeals from the district court cases. So let's go back to your example. You have a contract dispute. You sue someone, or someone sues you in federal court. Here, it would be in the Middle District of Tennessee. You will litigate that case, and let's say you lost, and you thought, I should have lost. I should have won. I'm going to appeal my case. That goes to the Sixth Circuit.
Okay.
And they actually sit in Cincinnati, I believe. They think, I guess that's central between Michigan, Indiana. Ohio. I forgot to mention Ohio earlier. I said Indiana was in the Sixth. It's Ohio.
Okay.
So Tennessee, Kentucky, Ohio, Michigan. So Cincinnati's where the Sixth Circuit sits. There are judges for the Sixth Circuit all over the Sixth Circuit, but the kind of home base is Cincinnati.
I see.
So you typically would drive to Cincinnati. You would argue in front of a panel of 3 of the judges on the Court of Appeals. There's a lot more than that. They sit in panels of 3.
Okay.
And then if you want after that, you can do what's called an en banc review. And that means you ask for all, maybe it's 15 that are in the circuit to hear it at one time, pretty overwhelming. They may or may not do that. And if they decide not to do it, or they do it and it still doesn't go your way, you can go up to the Supreme Court, which is the last option.
Okay. So to use a cultural reference here, and forgive my Netflix understanding of court districting and so forth, but the show a couple of years ago that was really popular for a period of time called Making a Murderer, and this guy in Wisconsin. Have you seen that show, Andrew, at all? Have you heard of it?
It's a good show.
Yeah, I've heard of it. Haven't seen it.
Yeah. I think we've watched, we got super sucked into season 1, and then season 2 came out and everything. Now, he made it all the way up to, I think, the thing where there was like 15 judges hearing that case, I think. So in that case, they were in Wisconsin, and they kept appealing, with their innocent pleas, and they got kicked up, just farther up the ladder. And I don't know that ever made it to the Supreme Court. I don't think that it did, but it made it up about as high as it could go without going to the Supreme Court. Yeah. So is that what you're talking about when the 15 judges get together? I
don't know, because my understanding is that his conviction was a state conviction, so that may have been in the state court system. And maybe they had that many. You can still actually challenge a state conviction in federal court through what's called a habeas corpus petition. It's this whole kind of set of proceedings after you've exhausted your state court options. You can file what's called a habeas petition in federal court and say that there was some constitutional defect with my imprisonment.
Okay.
And so then that goes through the whole federal system too. So it could have been something like that, but I believe it was a state crime.
Okay, so if not, then it would have been a state crime, which
this doesn't apply.
Yeah, this is not. We haven't gotten a state yet. This is still federal. Got it. Okay, makes sense. All right, so we have these. Is that kind of the lowest level of federal then with
the circuits?
Districts?
The districts, yes.
Okay.
So yeah, you have federal district judges that, for example, the Middle District of Tennessee would hear any case that arose within that district. I think there are federal courthouses in Columbia and Nashville, maybe Clarksville. I have to think exactly where. And then in Western, there's Jackson and Memphis. And then East, there's Greenville and Chattanooga and Knoxville. And so basically wherever court you're closest to, you'll get a judge from that court. And then there are all the other judges called magistrate judges, which are actually appointed by the district judges. And they hear smaller disputes. So they may hear, like a discovery dispute, what documents get produced, something the federal judge is busy doing, trials, criminal trials, civil trials. And then magistrate judges actually typically sign search warrants and arrest warrants. So if you want to, you see in Law and Order waking up a judge in the middle of the night to get a warrant. If it's a federal judge, it's going to be a magistrate judge.
I see.
They're appointed for, I want to say it's an 8-year term, but they're not appointed for life. They're not appointed by the president.
I see. Okay. And that's the federal system.
Right.
Okay. And states.
There's
know about that?
50 different systems plus DC. So
is that because the Constitution essentially said the federal government only has the authority that the Constitution vests into it, but the states have authority? Essentially, it's just like they have the authority unless the Constitution denies it, right? Is that why we have all these differences in the different states?
That's right. It's the difference between what's called general and limited jurisdiction. So a federal system has a limited jurisdiction. The Constitution has to enumerate a power that the federal government has.
Yes.
The states just have whatever powers exist unless the Constitution takes it away.
Yes.
So for example, the easiest maybe one to think about is the 13th Amendment to the U.S. Constitution that says slavery and involuntary servitude, except as punishment for a crime for someone duly convicted, is abolished. Right. That means that they took whatever power a state might have said they had to have lawful chattel slavery was taken away by the federal government. Mm-hmm. So while people may say, and I would agree, slavery was not a legitimate form of power to be used by the state. It's inhumane. It's horrific. It's outside of the design of God. It's immoral. For all those reasons, the states were still doing it. It was protected by the law. The 13th Amendment took that power away, right? Mm-hmm. To the contrary, for the federal government to do something, the Constitution has to say it can do something. So for judges, that means that Congress has to tell them, or the Constitution has to tell them, you can hear this case, or you can't hear this case. State courts can pretty much hear anything, with some notable exceptions.
It's just striking to me that I didn't know that until more recently. It's just striking to me that the Constitution can give that amount of information on the federal side, saying, hey, you can act only if we allow you to, and then give this amount of information on the state side and say you can act unless we tell you not to. And this is all wrapped up in one document, and it seems to be working for the most part.
Yeah, what's interesting is there's this long doctrine called the Incorporation of the Bill of Rights to the states. And what's interesting, if you read the First Amendment to the Constitution, it doesn't say no state shall pass a law abridging freedom of speech. It says Congress shall make no law abridging the freedom of speech. So if you read it strictly, maybe the states could pass a law abridging the freedom of speech, right?
Oh, that is interesting.
So no state is currently passing laws abridging the freedom of speech that hold up in court, right? So why is that? And that's because of this doctrine called incorporation. And so over time, particularly because of the 14th Amendment to the Constitution, which does apply to the states, which says that no person shall be deprived of due process of law, or no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be deprived of the equal protection of the laws. That is applied to the states in the 14th Amendment. It was a Reconstruction Amendment passed after the Anti-Slavery Amendment. And so after that, the Supreme Court started incorporating the Bill of Rights prohibitions to the states. So they've said, you know what? It would really violate due process if a state abridged your freedom of speech, right?
Right.
It would really violate due process if they gave you a criminal trial without a jury, or if you weren't allowed to confront witnesses against you in a criminal trial. Those are all in the Bill of Rights, but it never been applied to the states. And over time, the court's done that. There have been maybe two that have never been incorporated as to the states, and that is the Third Amendment for quartering soldiers in your home. I don't think it's ever really been applied. And then one regarding juries for civil cases. So you're entitled to a jury for all cases for which you would get a jury at common law in a federal court, and that has not necessarily been applied to the states. So the state doesn't have to give you a jury trial for a civil case, but they do for a criminal case.
I see.
So you have this doctrine called incorporation. And then you have this doctrine called I'm going to blow your mind, called reverse incorporation. There's nothing in the Constitution that says the federal government has to guarantee the equal protection of the laws. That's in the 14th Amendment that applies to the states. The Supreme Court has reverse incorporated that to apply to the federal government. So let's just assume they all apply to everybody at this point. But yeah, so that is an interesting way that they've taken some powers away from, the court has taken powers away from the states.
Okay. You lost me on that last point.
Okay.
How do they take what? Say that again. They took some. They reverse engineered something there, but I didn't understand it.
So there's basically the 14th Amendment, by its terms, applies to the states.
Yes.
Over time, the courts have applied it to the federal government too.
Oh, I see.
So they call that reverse incorporation, where they've incorporated the other things from the federal government to the states. They're now reverse incorporating this state-only provision to the federal government.
Yeah. Gotcha. Interesting.